All right, good afternoon. This is Judge Elisa Bettis presiding over the 210th District Court criminal docket for September 9th, 2025. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. We are also streaming all matters live via YouTube for public viewing. I'll go ahead and call the first case. This is 2025 0D0 3288. Let me just check. Do we have a prosecutor?
Judge, I am here. However, my video says it's disabled by the host.
Ooh, okay.
So I really, there it is. Now I can. Thank you.
Okay. All righty. This is State of Texas versus Justin Charles Ocon. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Michael Blake for Mr. Ocon. We're ready, Your Honor.
And for purposes of the record, Mr. Ocon is appearing remotely from the jail annex. Is that your client, Mr. Blake?
Where's he at? Yes.
Okay. All righty. So we are set for a bond hearing. You may proceed.
Yes, Judge, and also present is his significant other. She's in the office here with me now.
Oh, okay.
Judge, Mr. Ocon is charged with aggravated kidnapping and assault by impeding breath. His bond, I believe, is at $150,000 cash surety with a PR attachment to that. We were here for a bond reduction several weeks ago. We were not able to attain the bond at its present amount. It had to be significantly reduced for Mr. Ocon to have a chance to make that bond. Being able to acquire the bond will also enable us to work more closely on his case. As it stands now, I know when anybody sees an aggravated kidnapping charge with a deadly weapon, it kind of gives any person pause. But now that we've had a little bit of time to look at the file and the facts surrounding this case, without trying to get into too many fact scenarios, the injuries that the complainant received, I would describe of a nature as what would commonly occur in a misdemeanor assault case. There were medical records attached. Part of the allegations were that Mr. Ocon hit the complainant with a pistol. However, what the medical records note is that there's no hematoma to the scalp area. There was a small, slight contusion to the center forehead, as well as some marking and bruising on her face, including her eye. And she had what we would call in the old days a fat lip. The other part of the allegation, as far as the aggravated kidnapping is concerned, is the indictment alleges that she was abducted by secreting her away in a location that would be the location where Mr. Ocon's residence, and the complainant, Crystal Contreras, had been to that location on numerous occasions. They had an ongoing relationship. The night this occurred, there were other individuals there. So I think the abduction by secreting is something that could be hopefully effectively fought if we have to resolve this through a jury trial. The other medical records within the file describe pain as being dull as reported by the patient. That would be the complainant. There's also an allegation of the assault by impeding breath. There are pictures of Miss Ocon, and she does have marks on her face, like I said, but from a frontal perspective, on the photographs I've been provided, there is no substantial bruising or red marks to her neck. There seems to be a scratch or something to the side of her neck, maybe, but I'm not even sure if that was a scratch. My client, Mr. Ocon, did cooperate substantially with law enforcement once they contacted him, which was within 2 days of the allegation having arisen. And they did search his house, and they did not find any pistol that was described by the complainant in the course of these events. So we'd ask the court to consider all that. He has a prior family violence that was dismissed, I think, a little over a year ago. And we would ask for a bond, cash portion in the neighborhood of $7,500. No contact with the complainant, obviously, and to enable he and his family to be able to raise the funds to meet the bond and help prepare his defense.
All right, Mr. Garcia?
Yes, Your Honor. So the state will argue that the bond is reasonable as is. As Mr. Blake has stated, the allegations and the offenses in these cases are alarming. Yes, they are alarming, Your Honor. As I may recall, none of these statutes require for any bruising or injuries to be sustained by the victim in order for us to satisfy the elements. Nonetheless, I would like to point out that the report does mention that the victim did sustain an eye vein rupture, the temple was bruised, the cheekbone was bruised, and there was a bruise behind her ear. Her eye, she sustained injuries to her forehead or her nose, her temple. You can see scrapes on her elbow and her arm. And again, I could go on and indicate all the injuries she sustained. Nonetheless, Your Honor, in a perfect world, she wouldn't have to sustain any of these injuries at all. And in fact, we do have them here present. And he is charged with aggravated kidnapping with the weapon. There was a weapon present. He did impede her breath. There is an allegation that he impeded her breath with using his hands. He slapped her around, or he struck her face. Whether there was people present or not does not negate the fact that she was unable to leave the place where she was being held. She was assaulted by the defendant. Again, Your Honor, this is an aggravated kidnapping and assault impeding breath. For those reasons, the state will argue that the bond is reasonable as is.
Judge, and I left out one issue, and I think having people around at the residence and having been there does go to the factual consideration of the secreting. But also what the file does say in the arrest affidavit is that at some point over the night where all this occurred, they both fell asleep. In the morning, Mr. O'Con left for work, and that is when the complainant was able to leave the house. And I bring that up for your general consideration, but also for the specific consideration that on aggravated kidnappings, if the victims are released in a manner such as that, it knocks it down to a second degree consideration for the jury.
All right. Yeah, the request to reduce bond is denied. Thank you.
Thank you. Jose, can we talk about maybe final resolution of this also sometime in the near future?
Yes, sir. Of course.
Okay, I'll be in contact with you.
Please.
Thank you very
Yes.
much, Mr.
Thank
Blake.
you, Anna.
Who's next?
Judge, on page 24, we have Mr. Vasquez for Michael Luna. Annex, can we get Luna next?
Thank you.
Good afternoon, Your Honor.
Good afternoon. Mr. Luna has a new case, huh?
Yes, Your Honor.
Okay. Oh, we're there? Okay. Calling cause numbers 2023-0D04987, 2023-0D01658. Are you asking for any relief on the bond on the new case, Mr. Vasquez?
No, Your Honor, I'm just asking for the court to set bond on the probation cases.
Okay, so those are the two cause numbers. State of Texas versus Michael Aaron Luna. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Good morning, afternoon, Your Honor. Joseph Vasquez representing Mr. Luna, and we're ready.
For purposes of the record, Mr. Luna is appearing remotely from the jail annex. We are set for bond hearings in each of these cases. You may proceed, Mr. Vasquez.
Judge, my client was placed on probation on March 26th of 2024. He resides and works in Carlsbad, New Mexico, where he's being supervised. And from all indications, he's been complying with the terms and conditions. Obviously, this new charge is an allegation. Basically, he came into El Paso and met with a friend, and there were no incidents. There was nothing that happened. And then he was picked up and charged with this. Judge Ben Ivy is an attorney that I believe represented Mr. Luna in the past, and I have not confirmed this with Mr. Ivy, but Mr. Luna tells me that the complainant in the case has contacted Mr. Ivy and told him that she lied and that she does want to sign a non-prosecution affidavit, and I'm in the process of trying to accomplish that. We're asking the court, the bond on the new charge is $15,000. We're asking for a low bond on these cases so that he can afford to bond out. If he would like to go back to Carlsbad and try and regain his job, but if the court wants him to stay in El Paso while the charges are pending, he will make those arrangements and stay in El Paso in the case until the case is done. But I'm asking for bonds no more than $5,000 on each case, Judge, so that he would have the hope of raising the funds so that he can bond out and deal with the cases.
All right, Mr. Garcia.
Yes, Judge. So I do agree on the part that the complaining witness may be inclined to sign a non-pros nonetheless.
Which complaining witness? The one on the probation case or the one on the new case?
The one in the new case, Your Honor. However, that still doesn't negate the fact that the defendant, in this case, he was violating curfew hours. He was also highly intoxicated. Those are the allegations of the new offense, Your Honor. So those are still violations during current probation. As Mr. Vasquez mentioned, he pled less than a year ago, and we are back here with some violations and new allegation for a new case. For those reasons, Your Honor, I believe the bond should be set. I think it's reasonable as is. And
No bond on the two
no bond.
probation cases, so he's entitled to bonds.
Right. So I believe I don't know, 50,000 cash surety should be sufficient.
Mr. Vasquez?
Judge, just to point out, he's been on probation since March 26th of 24, so that's almost a year and a half.
Mm-hmm. Let me look at the PSR. So when he pled, they dumped was an assault on a public servant, right? And then he pled on the harassment and AFV against a different complainant. Now, a year into probation, I have another complainant with some very troubling allegations. State is right. You know, the report says drinking, I guess, driving while intoxicated, possibly. And then, of course, the allegation against the new complainant. That's not good. The recommendation from probation is to modify him and for him to remain in El Paso. But frankly, I just don't care for new allegations of the same type, certainly violent offenses and some certainly of the same nature. So yes, the bonds on each of these cases are going to be $50,000 cash surety.
Times two, Judge, just to be sure.
For each case, yeah. So 50 on 4987. Well, we could, yes, and 50 on 1658.
Thank you, Your Honor.
We'll run them together with the new case and see where we end up. Okay, I did review the PSR. I guess PSRs are really updated because there is some failure to report in Carlsbad, but that's from like August 5th. And I'm gonna assume he was in custody here already on this case. So anyway. Alrighty. Thank you very much.
Thank you, Your Honor.
Next.
Sorry, Judge, on page 26, we have Ms. Nava for Brandon Walker. Annex, can we get Brandon Walker?
Good afternoon, Your Honor.
Good afternoon. Let me go back to my probation summaries. All right. Calling cause number 2024-0D01664, State of Texas versus Brandon Devontae Walker. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Alyssa Nava on behalf of Mr. Walker, Your Honor, ready to proceed.
Mr. Walker is appearing remotely from the jail annex on the bond hearing. He's at no bond as well, yes?
Yes.
Lead, Ms. Nava.
Yes, Your Honor. Mr. Walker originally pled to ag assault with a deadly weapon back in November of last year, where he was placed on deferred. It's my understanding he hasn't had any other violations except picking up this new offense. I've been provided with several screenshots and text messages from the complaining witness with her threatening to kill Mr. Walker, and then also calling him repeatedly throughout the day. Mr. Walker's wife was also present during the assault, the alleged assault, where the complaining witness tried to force her way into Mr. Walker's house. She dented their door by banging on it. Mr. Walker does suffer from PTSD. He was in the military for 8 years, 4 years being in the Army and 4 years being in the Marine Corps. He has been in El Paso now for about 7-8 years. His wife is also here as well. At this time, there's not much that they can afford, and we are asking for a potentially $5,000 bond, if not lower. Or we're also asking if we just can keep him on probation while I work out the assault family violence.
So we had so many bond hearings. I assumed this was a bond hearing. I don't show it's a bond hearing. I show it's a probation status hearing.
Right.
Yeah. And I apologize, Ms. Nava, if I just said it because I thought it was, but I don't show that we have a motion to set bond. I can ask the state if they're okay going forward, but I only had us down for a probation status hearing.
Right, Judge, and I was going to object to insufficient notice for the state.
Okay.
Sorry.
No,
So in regards to the status, does the state know what they're wanting to do, or does the court have any?
Probation is recommending actually what you said, which is, of course, to continue on supervision with modification to order him to take BIP, screen for domestic violence caseload, and I thought I heard something about PTSD, so maybe some mental health screening as well.
And I'm okay with that, Your Honor.
Yeah.
I don't think that's an issue if we can modify them today or as soon as possible.
Have you seen the new case, Mr. Garcia?
I have, Judge, and from what I'm looking at, it seems that we're gonna have an issue finding the complaining witness. So for those reasons, I think we're okay with the modification.
Okay. Miss Carla, I see you're going to turn on your camera here. You have some input. Certainly, if we're going to keep him on, and it was for that reason, actually, the first thing I did was look for his PSR. I didn't have a PSR because we weren't doing the bond. Mr. Nanez, any chance you can run me a quick PSR on Mr. Walker?
Yes, ma'am.
I think I'm okay with it too, but let me look at the PSR, Ms. Nava, to see what we have in terms of history, whether it's here or somewhere else.
So he is currently on deferred probation. He pled to two terroristic threats along with the ag assault with a deadly weapon. And so those probations are running concurrently.
Yeah, I just want to see if we have anything either outside of El Paso or, so while I look at that, yes. It looks like the complainant on this case is different. He was not ordered to complete any classes. That's strange. Community service, he hasn't worked any, but he's been reporting. He was drinking back in March. So there's a lot we can do here. But it's going to include, obviously, no contact, something akin to a protective order, right? No contact, not be within a certain distance of the complainant in the new case. And then modify him for BIP and the domestic violence caseload. Do we know who the complainant was? Was it just non-related on the ag assault deadly weapon?
He was an employee at a car dealership.
Okay. Miss Carla, do you got any input?
Nothing, Your Honor. I just wanted to clarify, I know the summary states for the domestic violence caseload, but that's only if he were to
Plead on the new
plead
case?
guilty on the new case, on the assault. But in the meantime, we could actually modify him for bib counseling if that's,
Mhm,
he can do that.
mhm. Okay. I think I'm good with that, Ms. Nava. If you want to just stick around for a minute so I can review the PSR, so I'm sure if there's any other conditions. Is there any drinking allegations, anything like that in the new case?
Not my understanding, but I don't have access to it yet. I just have information from my client and information from his wife, but I don't believe so.
Okay.
I reviewed it, Your Honor. I didn't see anything.
Is there any, is he a veteran? Is there any use in exploring veterans treatment court?
And I believe he did apply for Veterans Court. I have, when we pled, he did the screening. Let me see.
I'm just thinking in terms of resources, if there's, stressors or anything that he can receive assistance from a more specialized probation. That
Yeah,
might,
we applied. I'm not sure why or what ended up occurring.
It wasn't part of at least for the terms and conditions, it wasn't put on there like to screen him or looked into for Veterans Court.
does he get does he get mental health treatment at the VA?
I know that I believe so, Your Honor. He is 50% disabled. It's my understanding he does, but I'm not sure at this point.
Okay. All right. Let me see that PSR. If you want to stick around, we'll come right back to you. I think I'm comfortable with that modification, adding maybe that I don't know if we can transition him if he qualifies to Veterans Court, to see if they have any additional resources for him. Okay.
Thank you, Your Honor.
All right. We'll come back to you. All right. Who's next?
I'm sorry, Judge, we have next Mr. Stevens on page 23 for Christopher Johnson Annex. If we could get Christopher Johnson.
Okay. All righty. Calling cause numbers 2024-0D05005 and 2024-0D06255. Each case style, the state of Texas versus Christopher Lee Taylor Johnson. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Brent Stevens for Mr. Johnson, we are ready.
For purposes of the record, Mr. Johnson is appearing remotely. We're set for bond hearings in each of these cases. You may proceed, Mr. Stevens.
Thank you, Judge. Your Honor, my client was recently returned to the 210th from the 384th Competency Court. He's doing much better now. His bonds are $40,000 for the aggravated assault and $5,000 for the evading. The aggravated assault was a fight at the OC, and most of it's on video. I believe it is something that eventually will be dismissed, in my opinion. The evading was on foot for a very short distance when he was attempting to get mental health treatment, but a police officer was going to arrest him for a warrant, and so he fled on foot, but it's a very short distance. At that point, he was having his 1622 issues very significantly. He's born in Louisiana. He's been in El Paso about 4 years because his family was in the military. We've referred him to jail reentry. They have linked him to the rescue mission, which is available for him upon release. If he is released, we're requesting that there be the special transportation orders being placed in the release order so that he could be transported to the rescue mission. Mr. Johnson is telling me that he will show up to court every time. For mental health issues, he is being referred to Takumi. He has an appointment on the 16th at 8 a.m. And I have the phone number and person he's supposed to meet with at EHN. After that, they are also going to link him to benefits access, which they will help him apply for benefits through his Social Security. So that's where we're at. He's not eligible for a straight PR bond because of the aggravated assault, but if you could set it as low as possible, we would appreciate it. I do not believe he has much money, if any.
All right. He's got an extensive history, Mr. Stevens, and I understand that mental health is probably an issue here, but I have a 45-page PSR with extensive violent history. Mr. Garcia, go ahead.
Yes, Judge. I was just going to mention that as you mentioned, he does have extensive history. Whether or not all this history involves mental health issues, part of my duty is to maintain or to secure that we can maintain the community safe. And Your Honor, for those reasons, I believe actually, I was going to say that I agree with Mr. Stevens, the recommendation that you sent me.
You're in agreement with that?
Yes.
We'll accept the offer then.
I think he's time served, Judge.
Okay.
We can send up for a plea. I think that resolves the bond hearing.
Well, the bond, the request to reduce bond is denied. So, the bonds I think are reasonable, even in light of the mental health history. And so that'll resolve the bond issue. If there is some resolution now to the case, please get the paperwork going. The sooner we're done, the better. Okay?
Yes, Judge. I'll send them to Mr. Stevens.
Thank you both. Thank you very much.
Stevens. All right. Next. Thank you, Mr. Johnson. Your attorney will be in touch.
Judge, next we have on page 25, we have Mr. Rosales for Ms. King, and it requires an interpreter. Mr. Cifuentes just logged on.
Okay, so we have Ms. King from Rosales.
Yes.
Hi, Ms. King, how are you?
I'm good. How are you, Judge?
You're now a federal practitioner?
Yes.
Why are you laughing, Mr. Garcia?
I saw the photo too, Judge.
Yeah?
Hey, it's a latograph.
It was a good picture.
Thank you, Judge.
Let me see. Okay, so this is Ms. Rosales.
Yes. Annex, can we get Rosales, please?
Let me write out.
Thank you.
Good afternoon, Mr. Cifuentes. Is this the only individual for whom we need a court interpreter?
Yes, ma'am.
Great. If we can get that set up, please.
Annex, could you select Spanish, please?
We're on it.
Yes? Oh, let me.
Sí,
select
señor.
English.
Gracias.
Perfect. All right, calling cause number 2024 0D07468, State of Texas versus Lisette Rosales Cruz. May I have announcements, please?
Jose Garcia for the state, present and ready.
Roll for Mrs. Rosales. Good afternoon, Judge.
Good afternoon, Mr. Garcia. I don't think I heard you, so maybe select English. Thank you. All right. Okay, and Ms. Rosales Cruz is appearing remotely from the jail annex. She is also utilizing the assistance of a court interpreter, Mr. Jesus Cifuentes. We are set for a bond hearing. This is a PR revo. She's at 100,000. Ms. King, you may proceed.
Thank you, Judge. Judge, I was recently retained by the family to represent Mrs. Rosales. She does, from my understanding, I spoke to the state this morning, or this afternoon, actually. She does have an ICE hold. Her immigration renewal was actually ended in May of 2025. So she is sitting on this case. She also has a misdemeanor case of criminal trespass, different complaining witness than the one we have here. The victim in this case is the alleged ex-husband. There is a divorce that's pending as well. Judge, she does not have any criminal history. She's 25 years old. But again, Judge, this bond reduction was requested before I hopped on the case, but I don't think it's going to do anything as far as getting out because she has that ICE hold. We are in the works to attempt to see what we can do to as far as a plea for both cases. That's all I have, Judge.
What is do you have the rec, Mr. Garcia?
So on this case, Your Honor, yes, the recommendation is a Class A to reduce to a Class A to use deferred. However, Ms. King and I spoke earlier today. She did give me a counter, which I will discuss with my chief to see if we can go that route. But in any event, Your Honor, the state's not opposed to a reduction in bond. I know she may not be entitled to a PR bond because of the nature of the offense. However, at this point, the state's not opposed to a bond reduction.
So she's right. You're right. In terms of the PSR, it's this case basically. And before we had the PR violation, she was at an $8,000 cash surety or PR. I just wrote down 8,000. So it was a low bond. So we'll do a $5,000 split bond, 2,500 cash surety, 2,500 PR to report once a month, commit no new offenses, possess no weapons, and have no contact with the complainant. Those will be the conditions on the PR portion of her bond. Okay.
Thank you, Judge.
Thank you very much. All right, we're adjourned on that one. And can we go to Roscoe, I guess? And if no one else needs the interpreter, Mr. Cifuentes, you are excused. Have a good day. Oh, here it is. Thank you, Annex. If we could have Randy Jean Roscoe.
Yes, Your Honor, please coming right up.
Thank you. All right, calling cause number 2025 0D05171, State of Texas versus Randy Jean Roscoe. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Robert King for Mr. Roscoe.
For purposes of the record, Mr. Roscoe is appearing remotely from the jail annex. We are set for a bond hearing. Ms. King, you may proceed.
Thank you, Judge. Judge, Mr. Roscoe he is 69 years old. He's been in custody over this charge, allegations that happened back in earlier March of this year. A little over a month that he's been in custody. He's been in El Paso, residing here for 11 years or so. He works for Mr. Steve. It's a broker company. His boss name is Steve Chaparro. I've been in contact with him. He is the broker company's the alleged complaining witness on the indictment for the arson. Judge, you will see that he does have extensive criminal history. I do understand that he does have suffering from various medical issues. He has diabetes. He has skin cancer. Judge, if he does not have any family here, but he's calling it home. He's been calling El Paso home for the last 11 years. Your Honor, I did speak to Mr. Garcia earlier this morning regarding a plea, and I believe they were in agreement to do a 1244. And that's all I have, Judge.
Mr. Garcia?
That is correct, Your Honor. We've reached an agreement for 1244A. Nonetheless, I did advise that I was opposed to a full PR because of his expensive history, but I think this case has been resolved.
Yeah, the request to reduce the bond, I'm showing it's 10,000 cash surety is respectfully denied. So get the paperwork going and we'll take care of the plea as soon as possible. It is a 35-page PSR. Thank you very much, Mr. Roscoe. We'll be in touch with you.
I will visit you, Mr. Roscoe. Thank you, Judge.
If you don't have anything else, good to see you. You're excused.
Thank you. You too. Bye, everybody.
Bye.
Who's next?
Judge, next I'm on page 23 We have Ms. Rodriguez for Jimmy Elizondo. Annex, if we get Elizondo.
All right, Ms. Rodriguez, are you ready? Yes.
I am, Judge.
Calling cause number 2025-0D04830, State of Texas versus Jimmy Joe Elizondo. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Karina Rodriguez on behalf of Mr. Jimmy Elizondo, defense is ready as well.
And for purposes of the record, Mr. Elizondo is appearing remotely from the jail annex. We are set for a bond hearing. Ms. Rodriguez, you may proceed.
Thank you, Judge. Mr. Elizondo is respectfully requesting that this court reduce the current bond amount, which is set at $110,000 cash or surety. We are asking for the court to reduce the bond as he's unable to post any amount at all at this time. If released, he would reside at 8021 Meraz here in El Paso, Texas, 79907. He would reside with his mother at that address. Mr. Elizondo has indicated that he does have two children that he supports financially. One of them is age 13, the other one is 12. Mr. Elizondo did mention as well that his ex-partner suffers from stage 4 cancer. She's the one that looks after the children, and they do rely on Mr. Elizondo to financially support that family as well. Prior to being arrested, he was working at Intertwined Engineering. He attended Del Valle High School and obtained his GED as well. If released, Mr. Elizondo would have access to a phone and transportation as well to help him show up for his court hearings. And for those reasons, we're respectfully requesting that this court consider reducing his bond amount. Thank you.
Thank you, Mr. Garcia.
Yes, Your Honor. Mr. Elizondo is a habitual offender. He does have an extensive history, most of it relating to drug related offenses. Again, he is a habitual offender, Your Honor. He's been to the pen at least twice. For those reasons, we believe the bond is adequate as it is.
So the PSR does have unauthorized absence from a community correctional facility. That's, I think, kind of after the assault on a public servant. 2002, we got an ag robbery. Very serious offenses. Can we go for a stretch, I guess, and the 168, not guilty. Bear with me. Obstruction, retaliation, 2021, and then does that get us to us? Assault, and then that gets us to us. There were no co-defendants on this case? Yes. Passenger Chavez. Anything else, Ms. Rodriguez?
Not at this time, Judge.
Okay, so I'm going to deny the request to reduce bond at this time. Thank you very much.
Thank
All right. Who is next?
Judge, staying with Ms. Rodriguez, on page 21, we have Daniel Barrientos. Annex, will you get Barrientos?
Yes, that's probation status. No?
It is. Your Honor, I did also file a motion to restore property on that one, but that was prior to the court setting the probation status hearing. I think it's moot at this time.
I know I looked up Mr. Barrientos and I should have written some notes. Let me go back to the probation summary. Okay. All right, this is 2025-0D00195, State of Texas versus Daniel Casanova Barrientos II. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Karina Rodriguez on behalf of Mr. Daniel Barrientos, defense is ready.
And we're set for a review hearing and a probation status hearing. It looks like I have down the motion to restore property, but I understand that's moot, Ms. Rodriguez. Basically, Mr. Barrientos picked up a DWI third shortly after being placed on probation and a drug case. Has that been indicted yet?
Let me check, Judge.
Okay, Ms. Nieto says no, it hasn't. So we'll be getting it. For now, Ms. Rodriguez, there's a recommendation, just so we go over the probation status. There is a recommendation. Probation is saying to modify him to be put on a portable unit and screened for substance abuse caseload. I'll take that under advisement, but for now, I'm not going to modify or do anything until I see this DWI. Okay.
Understood, Judge.
Okay, so I'm going to put you down for about 30 days for another probation status, just to check on our new case, see how quickly we get that new DWI and drug case in our court, okay?
Sounds good, Judge. Thank you.
Thank you very much. Is that all you have?
That is all I have. May I be excused?
Have a good day.
You too.
All right. Are we on, Mr.
Your Honor,
Monday?
I'm sorry, just real quick. It's a new DWI and a new possession. And I know
Correct.
Ms. Rodriguez just got off.
Yeah, no. It's a third and a drug case.
Yes.
So we have a few coming. Okay, so let's go to Mr. Hunt, maybe?
Yes, ma'am. Page 23 for Mr. Huffman.
Before we go there, Miss Nava was waiting.
Yes, Your Honor.
Sorry.
No, you're okay.
Let me go back. Because I review things and then I put them away and then I go past them. Let me see. Walker, yes. Going back to Walker. I am good with the modification that we discussed with the screening to see if we can't get him into Veterans Court.
Perfect. And I have the application, so I'll go ahead and send, or I'll reach out to the 346.
Okay. So we
Okay,
need
thank
to
you.
have him released. Mande, Carla.
Do we include the BIP as well at this time?
Yes, ma'am.
Okay,
Yes.
thank you.
If Veterans Court, I mean, we don't know if he's going in or not, and if they decide they want to modify that, they can do that later. So let's go ahead and include that as well.
Your Honor, I had a quick question. Do you want me to release today or you want me to wait for the mods?
No, we can release today.
Okay, thank you.
Thank you. All righty. Thank you, Ms. Nava. I'm sorry.
Thank
I
you.
forgot you were there.
No, you all have a great day.
You too. Okay. Who's this one? Who's next?
Mr. Hunt, Judge, on
Ah.
page 23 for Mr. Huffman.
All righty.
Annex, we get the Hunt, please.
Tell me right now.
Thank you.
Okay. Calling cause number 2025-0D02508, State of Texas versus Mark Stevens Hunt. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Rick Huffman for Mr. Hunt.
And Mr. Hunt is appearing remotely from the jail annex. We are set for a bond hearing. Mr. Huffman, you may proceed.
Your Honor, Mr. Hunt has been in custody over 5 months now on this case. The bond, I believe, is currently set at $3,500, if I'm not mistaken. It's a split bond, and he's been unable to afford that. We're just waiting for trial. I think we are set February of 2026. My client is a United States citizen. Sorry, Judge. He's a United States citizen. He's a resident of El Paso. He's been living in El Paso for about 2 years. Before that, he was back and forth to El Paso. He has a daughter here. He currently lives with his daughter and the daughter's mother in El Paso. Judge, but he does not have any money for a bond. This incident, Your Honor, it involves my client being at a motel. He took a bag from the motel room. He thought it was his bag.
Ends at Chick-fil-A?
It was at a motel. When he realized it was not his bag, he gave the bag back to the owner of the bag and left. And he went down the street to the Walmart parking lot where there was a Chick-fil-A, and he sat and ate a sandwich, not thinking that he had done anything wrong. I don't think he knew that he took a bag without the owner's permission. He was kind of in and out of sleep, Judge, in a motel room. It's kind of well, we do intend to dispute the facts of the case. We want to fight the allegations, Judge, but he just can't afford the bond. So we are respectfully requesting a full PR bond, Judge.
Yeah.
He is employable, Judge.
There's a drug case too, right?
There is.
Yeah. So 2025-0D05. Let me see.
They're both state jail possession cases. It's 2 counts.
Why isn't it listed here? Marissa, do you see the cause number on the drug case?
I have it. I just had
Go
it.
ahead.
It is 2025 0D05087.
And that one I show a bond of 1,000, and this one is set at, was it 10,000 or 75?
It's a 10,000 split bond.
Correct. What's the split? Is it 5 and 5?
That I don't have, Judge. I thought it was a $3,500 bond.
3,500.
3,500.
And I forgot to mention, Judge, my client does have available employment. So he believes that he does have a job waiting for him if he gets released.
All right, Mr. Garcia.
Yes, Your Honor. Well, I'll agree with Mr. Hoffman that the facts in this case are a bit circumstantial. Nonetheless, Mr. Hunt does have a long history of offenses. He has a 20-page rap sheet. Your Honor, for those reasons, we believe the bond is reasonable as said in order to maintain the safety of the community.
Yeah. I don't think I can go, if it's at 3,500 split on the burglary habitation, I think that's reasonable. I'm not gonna go lower than that on the cash surety portion, so the request to reduce bond is denied.
Judge, and if I may, is there an impossible offer out there, Mr. Garcia, that I could possibly take to my client? The 1244A type?
I'm not quite there yet. I was thinking more 6 months stay jail.
Yeah, I think I think we're almost there. So let me if you can make that offer official, and I can take that to my client, that I think that might, it's not what we were hoping for, but
It's official.
it's official.
Yes.
Okay, I'm gonna give you a call, Mr. Hunt. Hopefully I can get you in this week. Okay.
Thank you very much.
You have 5 months already, so we'll talk.
I have to wait on the state to do all that. One guy been here 8 months. Wait.
You got 5. Yeah, I'll call you this week. Okay, okay, sir. I'll give you a call.
Thank you, sir. Your hearing is adjourned.
Sorry, Judge.
Okay,
Thank you, Your Honor.
this is Mark Sasha is next. Is that yours, Mr. Huffman?
It is.
Calling cause number 2025-0. Oh, sorry, we need Mark Sasha. Sorry, Annex. Uh-oh, I hope your client didn't get me sick.
Was it my client?
Whose was it?
Hey, it was yours.
It was.
Yours. You're not sick. Mr. Sasha, we'll get started with your hearings now. This is cause numbers 2025-0D02912, 2025-0D02687, and 2025-0D02686. Each case style the state of Texas versus Mark Wilhelm Sasha. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Rick Hufford for Mr. Mark.
All right, we are set for bond hearings in each of these cases. Mr. Huffman, you may proceed.
Your Honor, my client, Mr. Mark, is a United States citizen. He has been in custody for over 5 months. These are 3 different incidents, 3 different indictments, and I believe the bonds total about $60,000. Outside of jail, Judge, he resides with his mom. He plans on working at a tire shop in Alameda. He also works at Red Cap. Judge, while he's been in custody, he has been participating in the reentry program. It's my understanding that is a program they offer in jail to basically treat his substance abuse and also give him life skills courses. He's done really well with that program, Judge. He actually hopes that one day he could be a reentry coach. As far as the cases, Judge, none of these cases allege that my client was actually in possession of these, or that he was never found in possession of any controlled substances. They're very strange, okay, Judge, in that regard. There's a number of videos missing on basically each case. They're all over a year old, Judge. And if I could go through it, I don't want to go through each case, Judge, but none of these cases involve my client actually found with drugs. But anywho, Judge, he's also has a trial set in February, which I think is a long time. I'm hoping that he can get a bond that he could afford, which isn't much. Between his mom and his sister here in El Paso, they don't have much money for a bond. So we're asking for significant reductions, Judge. He promises to abide by any conditions of PR bond to appear in court. We're hoping he's given that opportunity, Judge, because like I said, all of these cases are fightable, are defensible. I have not seen any evidence in this case that will convict my client on any of these indictments. So I'm hoping that either we can resolve the case with something reasonable, or judge that he can post bond and fight these cases.
Okay. All right, I have an extensive PSR, and I just seen in the jailings here, I've got parole violation in 21, parole violation in 22, and a slew of new arrests. So, total bonds I'm seeing on this jailing, so he's been in custody since April. Total bonds I am seeing are 72,000, but I think they're about 10,000. 1, 2, 3. So one of them is at 30,000. The manufacturer is at 15,000 split. Yeah, these are all, it's just cumulative. There's just so many. Mr. Garcia?
Well, Judge, after what the court has mentioned, I don't have much to add other than there is a pattern of reoffending. The first indictment is from April the 6th, 2023. And then June 4th, 2024, September 25th, 2024. Most of them dealing with drug-related offenses. The other one is unlawful possession of a firearm by a felon. He does have a history, Your Honor. Fightable or not, whether these cases are circumstantial or not, Your Honor, there is a pattern of reoffending. For those reasons, and for the safety of the community, I would argue that the bond is adequate as is.
And if I could briefly respond, Judge.
Yes, sir.
Just to give an example on that unlawful possession of a firearm, my client was never arrested that day. He was never found with a gun. He was never found with drugs. That's just one example of these cases. I think my client was targeted. He's alleged to be a gang member, but Judge, he's not a gang member. He has tattoos that he's had for a long time that do not, they just don't represent him being in a gang. So I believe that he's been unfairly targeted, and that's just one example of instances out of all these indictments, Judge.
Yeah. The request, I'm looking at the PSR. It is an extensive drug history, some non-compliance on probation. Looks like San Antonio. I mean, it's been a straight shot since about 2008. So, yeah, we're almost about 20 years of arrests. He's been to prison, evading, drugs. And I guess
one of the reasons why he wasn't arrested at that point is because he fled on foot.
Mhm.
But the ID is very weak. How do we know it was him who fled on foot? It wasn't his truck. It was, I don't know. I guess that's debatable. But
do I have a waiver of arraignment on him?
no, I don't believe so, Judge.
Because I'm hearing you say his name is Mr. Mark.
It is.
And I do see some entries in the PSR. His first name is Sasha.
Sometimes that gets flipped.
Yeah. So make sure you correct that.
I will.
And so, all right. No, request is denied. Thank you.
Thank you, Judge.
All right. Is that our last inmate?
Yes, ma'am.
All right. Annex, thank you very much. Have a good day. Stay safe.
Welcome, Your Honor. You
Thank
want,
you.
Your Honor? We had
Huh?
one more. Kissy one.
Yes, I had a notation there. Perdón, let me see. So this was, I had this as a deadline, is it Mr. Huffman or who had Yvonne Hawkes?
Ms. Carina, I believe, Judge.
It says deadline only requested by PD, not a hearing before the judge on Yvonne Hawkes.
Judge?
Yeah.
Let me. Miss Carina just wanted to add that hearing as, I believe she was working on a subpoena deadline or something. She needed that on the record or on the docket to show her deadline. But it wasn't a hearing. She didn't request a hearing. She just wanted it to show on the docket.
Okay. Thank you, Myrna. Who is this on the iPhone?
Good afternoon, Your Honor. My name is Bonnie Fuentes. I was summoned with PR. I was the officer for Yvonne Hawkes before she got revoked.
Okay. So I'm assuming that was at the request of the public defender's office?
Yes, ma'am.
Mr. Huffman?
Judge, Miss Karina is right down the hall. If I can just have a minute to go ask her.
Okay. So for now, Annex, yeah, we don't need Miss Hawkes. Thank you.
Your Honor, can we be dismissed?
Yes, have a good day. We can get off.
To
of
Your Honor.
YouTube.
Thank you.
So you've been waiting out there all this time?
Yes,
Where are
ma'am.
we? Okay, let me see if we can, in terms of the hearings are over. I'm not having a status conference on Miss Hawkes.
I'm not sure why I was requested because I wouldn't be much help for her. Like she wasn't very compliant.